I don't like the fact that I live in the desert in the summer, but boy, I don't mind that I don't get 3 feet of snow in a day in the winter.
No, the lake effect giveth and the lake effect taketh away. We'll just give people a few minutes to filter in.
That awkward time period when you're standing in front of the class and everything has set up and a hush actually went over, but you know that there are a bunch of students who haven't walked in yet.
It's almost worse virtually though, because you can see the names but not the people. And I'm just gonna give it one more minute here because we still have some people popping into the webinar, but I want to start soon because I know you guys have a lot to say and I want to have a lot of time for questions too. Okay, it's just after 1, so we're gonna get started. People may or may not filter in. For those who don't know, I'm Kiera Ward. I'm co-chair of CAL's Professional Development Committee. And welcome to the Canadian Open Access Legal Citation webinar. A couple of housekeeping things. This session is going to be recorded, so please keep yourself on mute if you are not already, just so we can keep distractions to a minimum. We just ask that if you have questions, you hang on to them until the end when there will be some time. So, as I've said, this webinar is on the new free Canadian Open Access Legal Citation Guide. Sorry, something popped up on my screen. Which was published in June 2024 and is available on Canly over the next little while. We will hear from some of its creators and learn more about why the guide was created, its benefits, and details of some of its citation rules, and the reasoning behind many of the decisions that were made in the process of creating them. Our speakers today are James Bachman. He is editor-in-chief of the guide and also the instruction librarian of the University of British Columbia, and an honorary lecturer at UBC's Allard School of Law, where he's the coordinator of the first-year legal research and writing program and teaches both first-year legal research and writing and upper-year legal research and writing courses, and I imagine does not get much sleep. Next, we have Anne-Marie. I think everyone probably knows our Anne-Marie. She is a past president of CAL and has been the librarian at the Court of Appeal for Saskatchewan since 2001. She is a co-compiler of the citation guide for the courts of Saskatchewan, prepared in 2015, and she is managing editor of the Canadian Open Access Legal Citation Guide. And then finally, we have Michelle Terrace, who is managing editor of this guide. She practiced law in Alberta before becoming the law librarian at Thompson Rivers University, which I believe is in BC. And she teaches advanced legal research and writing. So I am just going to pass it over to them.
All right, I'll share my screen. There we go.
Awesome. Thanks, Michelle.
Welcome.
Okay, welcome everybody. Thanks for joining us. I appreciate your being here today. So as was already mentioned, we're going to talk a bit today about the guide, which, as I'm sure you're already aware, is a legal citation guide. It's open access and it's available on Canly. So we're going to talk a bit about what the guide is, why we made the guide, some benefits of using it, and we'll look at some examples of citations and elements therein. Typically we say, please feel free to interrupt us with questions or put them in chat, but you've been asked to wait till the end, so I guess do that instead. And I also just mentioned that lots of thought went into making the guide, but we definitely didn't agree on all of the details of the guide, right? So we realized that not everyone's going to agree with every single decision that we made, every little piece of the guide. We don't all agree with each other, but we did put a lot of thought into it. We sent it to a lot of external reviewers, etc. So even if you don't agree, we definitely thought about what's there. This is a slide for introductions, but we've already been introduced, so I guess we'll move right on to, to the next slide. Thanks, Michelle. Cool. So there you can see the name of the guide, Canadian Open Access Legal Citation Guide. The English version was published this past June. The French version is in progress. We're hoping it will be ready this spring, although it might take a bit longer than that. The translation is proving a bit tricky in places. Like I said, it's hosted on CanLII. There's a link, direct link there. There's the CanLII citation there. You can also easily find it if you search CanLII for Cole Guide, comes right up, or even if you Google Cole Guide, for me, it's the first thing that comes up. So you should be able to find it pretty easily. The guide was created and is maintained by law librarians from across the country. In terms of our core team, we have librarians from almost every province. Most of us are academic law librarians, and we have Anne Marie, our one court librarian. Sorry, I've lost my place in my notes now. Yeah. Oh, that's the thing I wanted to say that I tend to forget. Yeah. So we, like I said, we have a very dedicated team, and I know one thing that some people have raised is a concern about is continuity. Like, what will happen years down the road? Will people still be paying attention to this? In terms of our creative team, yes, we absolutely will be. Like I said, we're very committed to this guide, and we've also committed to replacing ourselves should we step away for any reason, for retirement or whatever reason. We'll find a suitable replacement to keep things going. Okay, next slide, please, Michelle.
Okay, so it's great to be with you all today. Thank you for joining us. This is awesome. So what is this? This is the logo for the guide, and it contains a memento of the great period debate of 2022-2023. So what was this debate? Now, if you've heard me tell this story before, bear with me as I tell it one more time because not all of us will have heard this. So our working group of law librarians had decisions to make in relation to many aspects of the guide. And sometimes we were all in agreement, and sometimes we disagreed. And so if we disagreed, then we would have a vote on the issue. And we voted on all kinds of things, right down to the look of this logo. It really was democracy in action. So sometimes when we voted, of course, we were on the winning team, and sometimes we were on the losing team. And sometimes those of us who felt strongly about an issue really had to plead our case. So for example, I felt strongly that periods should be kept in citations in certain circumstances, and not everyone agreed. So we had a vote, and we thought it was settled. But then members of the working group thought about the issue between meetings, and then they asked James if we could discuss it again, which we did, and then we'd have another vote. So we revisited the issue of periods so many times that we ended up calling it the Great Period Debate of 2022-2023. And James even incorporated the period into the design of the logo, which he will explain now.
Yes, we've memorialized our great period debate in our logo. We chose a font where the O is round, like a period. We wrote the name of the guide in English and French around the border of the logo in a circle, like a period. And you notice the back of the background of the logo is opposite colors, is representative of a period that is both there and not there. So Schrodinger's period. Cool. So, why did we create this guide? A number of reasons. One big reason was people felt like legal professionals needed a guide that serves them, their clients, and their community. So there was some dissatisfaction going around with existing legal citation guides. And we felt like we could create a guide as professionals that would better serve the needs of professionals. But we weren't just thinking about professionals when we were creating the guide. We tried to keep all users in mind. librarians, lawyers, students, self-represented litigants, etc. We try to think about things from the perspective of readers, from the perspective of writers, with various degrees of familiarity with citation and law in general. So we really tried to make a guide that was going to work for everyone. And we try to think about different contexts in which the guide would be used. So for example, writing in academic journals versus writing for courts. Another thing that really drove this guide was cost concerns. So the McGill guide, for example, is so expensive. Excuse me, even the UBC Law Library, we don't have access to the electronic version of the guide. So we wanted to make something that people could afford. And we're also concerned about affordability for other people as well, like students, for example. Buying a physical copy of a book, it's a significant financial I can't talk. I get nervous when I'm being recorded. It's a significant financial burden on a lot of students, right? Sole practitioners, small firms can have troubles affording the McGill guide, etc. Self-represented litigants, it's not something they're probably going to want to have to pay for. So we wanted to make something that was accessible for people financially speaking. And another thing, thank you, Allison. Another thing is just the technology, the timing of this, right? We all got really used to working over Zoom during the pandemic, so it was quite easy just continue that tradition and just, meet with people around the country over Zoom.
Okay, I have to say, James and Michelle are professors, and they're used to speaking quite a bit, and they can just speak without their notes. And you're going to notice that I am speaking. So James, I am speaking following notes. So James, you are fine. No need to be nervous. So why use COAL, RJAL? So Michelle, yeah. Well, we believe that COAL addresses an access to justice issue. Proper citations are required in documents that are submitted to the courts. Everyone citing materials in Canada should have access to a free legal citation guide. They shouldn't have to purchase the guide or subscribe to a database that contains the guide or determine if a library near them has the most recent edition of the guide. COAL mitigates cost issues by being available free of charge for everyone to use online. So as James mentioned, many groups will benefit by a free open access legal citation guide. Self-represented litigants, solo practitioners, small firms, nonprofits, legal aid offices, and so on. The list goes on and on. COAL prescribes that citations from databases that exist behind paywalls should be avoided. For example, we ask you to avoid citations that include database identifiers such as Carswell BC from Westlaw, or OJ, the Ontario database within Lexis. And as well, to assist with open access, COAL points to open access citation guides in foreign jurisdictions. Michelle? Another reason, or a reason to use COAL is that our editor-in-chief, James, 8 managing editors, and 4 contributing editors from 7 provinces work frequently with citations, and we have the expertise necessary to write such a guide. As James mentioned, I'm the court librarian in the working group. Everyone else is an academic law librarian. They know how academics and students might look at an issue, and I know how we might view the issue at the courts, or how lawyers and legal assistants in a law firm might look at the issue. All of this played an important part in our decision-making, and we tried to keep self-represented litigants in mind. We carefully thought about all aspects of the guide, and we worked on it over a 2-year period. We had many meetings, and a handful of them were 3 hours long. Yes, 3 hours long. Sometimes the entire editorial group made decisions, but most decisions were made by small working groups that dealt with different sections of the guide. So the secondary sources, case law, government publications, international and foreign legal sources, and AI-generated materials. We had over 45 external reviewers from various user groups, jurisdictions, and types of Canadian legal settings review the guide and provide us their feedback. These legal settings included courts, law firms, law journals, law societies, and law schools. The only user group we didn't get feedback from was self-represented litigants. We spent many hours discussing the feedback that we received, and we went through each suggestion line by line. Sometimes we made changes due to the feedback, and sometimes we realized that we had already thought of the option presented. All the feedback we received was very much appreciated. And the editors will continue to incorporate user feedback and respond to emerging developments. Michelle? So, an example of the care that we took, we carefully considered how case law should be cited. So in this section now on case law, we'll note some of the similarities and differences between the McGill Guide and Cole. Michelle? By the way, I know that the acronym Cole isn't environmentally friendly, but pretend that it is. So, when you're citing case law and a neutral citation is available, that's what you use. The neutral citation here is 2015 AB QB 343. As you know, a neutral citation is a unique identifier for cases. It is assigned to each decision by the issuing court, tribunal, or administrative body. It is composed of 3 elements: the year of the decision, in this case, 2015, the acronym for the jurisdiction and level of court, here, Alberta, the Alberta Court of Queen's Bench, and the ordinal number, which is 343 in this case. So the neutral citation is a wonderful thing because you can use it to find decisions in databases such as Canley, Westlaw Edge, Lexis, Sokij, and so on. It doesn't matter if the database is available free of charge or if it's behind a paywall, you'll find the case that you're looking for. So if a neutral citation is available, please use it. And when it's available, when the neutral is available, a parallel citation is not required. So as you can see here, when the neutral citation is available, there is no difference between the way that McGill cites the decision and the way that Cole cites the decision. We both think the neutral citation is awesome. So most courts in Canada started assigning neutral citations around the year 2000. So if a case was decided prior to 2000, it likely won't have a neutral citation. In that case, both McGill and Cole state that the Canley citation can be used. So in this example, 1986 Canley 46 is the citation that Canley has assigned to R v. Oakes. Cole prescribes that when a Canley citation is used, a parallel citation is also required. In this case, we're citing to the Supreme Court decision, so the SCR cite is also required. Any parallel citation is acceptable, but preference should be given to the official reporters, which are outlined in Cole. Case summaries and reporters behind a paywall should be avoided. These are outlined in Cole as well. So why did we prescribe a parallel citation? Because with a parallel, it should be easy to locate that decision when you're in a database that might not recognize a Canley citation. If you enter the SCR citation in Lexis, Westlaw, Canley, or Sokij, and so on, you'll find the decision. Michelle? So, if neither a neutral citation nor a Canley citation are available, then 2 reporters are required. One is the main citation and one is the parallel citation. In this case, we're citing to the Dominion Law Reports, the DLRs, and the WWRs, the Western Weekly Reports. They are available in print and online in databases. Why is a main citation and a parallel required? Because as I said, it increases the reader's chances of finding the decision, in this case, either on the library shelf or in a database that they are using. Michelle? If neither a neutral citation nor a Canley citation are available, and you're pinpointing to a paragraph as it appears in an online database. Then after the parallel citation, include the paragraph number. Here it's paragraph 3, as well as the database you're using. In this case, we're using Lexis. Why do we include the database information? Well, it doesn't happen often, but sometimes there's a difference in the paragraph numbering from one database to another. So you want the reader to be perfectly clear about where you were looking at that paragraph, which database you were in when you were looking at that paragraph. Michelle? If you're pinpointing to the physical reporter, you'll want to cite to the paragraph number if it has paragraph numbers. If it doesn't have paragraph numbers, then you'll want to cite to the page numbers. We don't need to do this very often because so many Canadian decisions are now in Canley. This particular decision is not yet in Canley. So here, Westholme Lumber Co. versus St. James Limited can be found in both the Dominion Law reports and in the Western Weekly reports. But we're pinpointing to page 550 of the Dominion Law reports, because in 1915, the Dominion Law reports did not have paragraph numbers. And note that there is not a period behind the P up for the page number. Michelle? So McGill versus Cole, how do they look different when you're citing the print? Not that that's going to happen often, but it might. So note the difference between how the page numbers are cited between the styles. McGill has at 550 for the page number, and whereas Cole has at P for at page 550. And note the different use of periods in the case names. There are no periods in the McGill example, but Cole prescribes that periods are kept where they exist in company names. And here we've included the short name for the case as it's going to be referred to later. Michelle?
Okay. I'll take us through an example of citing legislation. So we wanted to talk about this to emphasize the fact that broad consultation has allowed us to account for idiosyncrasies between Canadian jurisdictions. For example, because Manitoba statutes do not follow the typical pattern, the guide includes the following information. So we have all of this information, mostly about the time when Manitoba statutes were all in English, and then translation had to happen, and going forwards, they're in both. And then the continuing consolidation of the statutes of Manitoba is a set public general act available online, how all of this works. So this helps the writer to understand what they're writing, as opposed to treating legislative citations like copying and pasting codes, which I know I've done, I know my students do frequently. McGill does provide some information specific to certain jurisdictions, but it organizes the information by statute type. So, revised statute, annual statute, loose leaf statute. Which requires the users to either read the entire section to get that information, or to already know which statute type they're looking for, and to find the correct information that way. Cole attempts to provide more user-friendly organization. Here we've listed information by jurisdiction rather than statute type, which the writer is much more likely to know, as well as more complete context and additional examples, of course. So this is one of the ways, again, not to toot our own horns, but we think that information professionals do a bit of a better job organizing the information to make sure that it's findable by the users. It's also modern. So we did try to make it format neutral. We chose to use format neutral rules for 2 reasons. So first is when a reader searches for a document that exists both physically and digitally, the elements included in the print citation will also allow the user to find the digital version. For a natively digital item like a website, however, the citation must specifically include digital elements. Word and page count are very serious considerations in legal documents. So each element in here has to be essential for retrieving or contextualizing the source. And we're trying to look towards the future and anticipate what's to come next. So that's why we have an AI section. But the main points here are that Cole was written in the context of the modern legal profession. And so that includes all of the modern legal technology that is involved with that today. So not only does it consider technological problems like citing AI-generated content, but it also reconsiders the uses and usefulness of each element in a computer-literate world. So for example, something that we do there is we don't have angle brackets around a URL. We just assume you see HTTP and you know that that is a URL at this point. Everyone is kind of there already. Same thing, we don't make you say online ahead of that because you see HTTP, you know that this is a URL. So we tried to think of things in terms of getting rid of all of the elements and bringing back in only what is essential, trying to think of it from the perspective of someone who's starting to cite today. So just the examples I was talking about. So if a source can be accessed online, you don't need to explicitly note that in the citation. There's a URL there. You don't need angle brackets. You know what you're looking at. And the Internet Archive's Wayback Machine is recommended and linked for users who need to create archived URLs, because this is a free service that expands an important publicly accessible archive with each use. So this goes back to our wanting to get away from paywalled resources as well. So instead of recommending perma-CC to make sure that we work around issues of link rot, this is why we go to the Internet Archive, because it's something that we know our users are going to have access to without having to pay money. So again, the ethos of it's not just that COAL is free to use, it's that we're trying to make sure that the way we prescribe citation is also low cost or no cost for readers and writers. So I've got here an example of what the McGill guide would say to do for citing a website versus what COAL would say to do. So we've got our authors. James can get into this a little bit more, but we do only use the first initials of author names. So T. Ross and H. Hinchcliffe. Then we've got the title of the website, same. Our dates are going to be the same. Then we go right into URL. And this is a little bit about consistency as well. Where possible, we always try to keep elements in the same place for every citation. So for McGill, sometimes it jumps around a little bit between secondary sources, between cases, all of those. So we're really trying to keep pinpoint at the end, except for very few cases where it would change in citing decisions at the moment. So author, title, date, URL. You can have the access date if that's really applicable, and the archived URL if it's applicable, then a pinpoint. We have a lot of things that say if applicable. We'll talk about that a bit when we get to flexibility, but everything, not everything, there are a few elements that are highly dependent on your situation. If you're just submitting something to a class because you're a student and it's going to be read immediately afterwards, there would be no reason to have to do this. So we try to highlight when something is situation dependent, and you end up here with a much shorter URL because we can say, well, if you've given someone the information, the title, the right to disconnect for federal workers, and you've given them the name of or the URL for the general website that it's on, if there's a search bar, they can find it. So the word count is a consideration when you're looking at the URL as well. We took out the requirements to remove the https://www and also adding the angle brackets. That is confusing. It's something my students always get tripped up on. I can't imagine self-represented litigants are nailing that 100% of the time. It's just, yeah, we're really trying to get rid of unnecessary elements there and unnecessary confusion. And of course, unless a resource is paginated, has section markers, or is a video or audio recording, you generally don't need a pinpoint here because it's a website. So this This all goes to consistency, back to what I was talking about a little bit earlier. So like elements are formatted alike and located in the same spot whenever possible. So some examples include using the @ when pinpointing all elements rather than only some. We'll get to that on the next page, but of course, McGill only has @ for a few types of pinpoints, whereas we say just introduce everything the same way, always @ para, @ section, @ page. Format, using quotation marks around the titles of sections of a work and italics for titles of the whole work. So a chapter in a book is going to have quotation marks around it. The book itself, that title is going to be italicized. Articles for journals have quotation marks around them. The journal title itself will be italicized, just to make sure that people are remembering rules as opposed to having to memorize something new every time they hit a new section. So our example for this is the pinpoint. Cole introduces a unique indicator for each type of pinpoint, while McGill omits an indicator for page. That's something a lot of students, and I'm sure people struggle with generally when they come over from using Chicago, using APA. Those always have an indicator for whatever type of pinpoint you're using, and then you hit McGill and suddenly there just isn't one for page. Cole instructs writers to always use @ before the pinpoint, where McGill instructs writers to use @ before some types of pinpoints, but not others. So there would be just article, but @ chapter, but just section, but @ para. So consistency makes things easier. James.
Thanks, Michelle. Okay, so this is where we emphasize that we really want to be responsive to users of the guide. We want this guide to work for people. So we really appreciate feedback on the guide, whether it's good, bad, or in between. We want we want to hear it. If something's not working for you, we want to know about that. If something is working for you, we want to know about that too, so that we don't change it if we get complaints about that thing. We also want to know about things that aren't in the guide yet, but you'd like to see in the guide. We have a very, very long list of things to add to the guide, but we need to prioritize that list because we're not going to be able to get it all out within the next year. So we're already making a priority list based on feedback we have received. So if there's stuff you'd like to see in the guide that's not in there yet, please definitely let us know. Canly does limit our updates to once a year at most. So we know, for example, there are some typos in there. They're fixed on the version on my computer, but we're waiting to upload it to Canly. We also want to add some expansions and things like that before we send Canly the new version. Like I said, the French version will be coming soon-ish, hopefully within the next about 6 months. And of course, we don't have any monetary incentive to make changes to the guide, right? We're going to make changes if it really is necessary based on user feedback or based on, things like evolving over time, things sort of change, new technologies come out, whatever. So we really are going for consistency and user friendliness. And please reach out to us. If you know any of us, feel free to reach out directly, or you can reach us at our email address for the guide, which is cole.rjal@ubc.ca. It's here on the slide. It's also available on the guide itself at the very, very top before the intro. Canly wanted to make consistent the getting in touch with authors parts of their documents. So in the questions or comments section at the very, very beginning of the guide, you can find our email address there as well. So yeah, please do get in touch if you have any feedback at all. We really appreciate it.
All right, back to me, more talking. Here we go. Flexibility is something that we're really concerned with. It's Cole RGAL was designed to provide as many solutions as possible with the fewest sections possible to avoid overwhelming the user. This is not to say, going back to James's point on responsiveness, if you don't see something and you're really feeling like, but there's nothing in here that's allowing me to do what I need to do, please do tell us. We will add more sections. Our philosophy, though, is that no guide can list everything a user might need to cite, and the more sections a guide has, the more difficult it can be to use, especially for those just learning. While we will absolutely increase the number of sections in years to come, we strive to write each section with enough flexibility that it can apply as broadly as possible. So additional sections are only included if the current sections do not provide enough information to allow the reader to find and contextualize the cited source. So for example, we've got future sections coming up, citing evidentiary resources, citing reports. We definitely do need these, but we're also trying to write this in a way that allows us to have as few sections as possible that you can apply as broadly as you need. And this all comes down, most of what I've spoken to comes down to it being easy to learn and use. So the system is designed to be easy to learn, eliminating unnecessary complications like we took out IBID and supra, and time-consuming tasks like finding abbreviations in an appendix. So there's no more, how is this journal abbreviated? It's not on the journal page. Or if it is on the journal page, is it different in the back of the McGill appendix? Took it out. To this end, we strive to keep the citations as concise as possible. Each element must be necessary to allow the reader to locate the cited item and understand its context. To explain this a little bit, by understand its context, we mean to be able to evaluate whether the source provided could actually support the claim being made. For example, the context elements help a reader to tell if the source is binding or persuasive, whether the treaty applies to the nations or date range being discussed, whether the prompts used were sufficient to rely on the answer generated, etc. So our example here is case names. We want to reproduce case names as they appear in the database or reporter in which the case is found, but we don't include a period after the V for versus, the C for contra, or the R for Rex or Regina. So we've got Tran v. Armstrong, looking the same either way. Those are just the names. R v. Oakes, same. But like Anne-Marie mentioned, MacArthur v. Dominion Cartridge Co., the company's legal name has a period in it. It would be strange if we changed the way that company spells their name. So we try to make it a little bit more intuitive, and make sure that what the clerk wrote down also is paralleled by the citation. Our other example, like I mentioned before, is no more journal abbreviations. So McGill requires writers to look through Appendix D to find the title of their journal and the appropriate abbreviation. If the journal is not found in the appendix, a writer has to use a chart of common words and abbreviations to create that abbreviation. And I understand that to an extent because, again, word count is important. But Cole instructs writers to use the title of the journal because that all takes a lot of time and it makes it more accessible for the reader if the reader can just read the title of the journal. If they are from a different discipline and don't know what they're looking at, this is all opaque. If they are a layperson trying to better understand the law and now they've just run up against a jumble of letters, this is opaque. So saving the writer time, making it more accessible for the reader. Short name and repeat references. We add a short version of the case name and square brackets at the ends. McGill and Cole both do that. You can use to refer to the case throughout the remainder of the document. Not necessary if you only refer to the case once. However, in McGill, you have to learn the rules for using IBID and supra. So you've got one citation, Tran, right below it. It has to be IBID. And then if you have an intervening citation, you have to use supra for the same one after that. In Cole, we just have Tran. Great, we've done the whole thing the first time. We've said what the short name is going to be. Use that short name again at paragraph 15. Intervening case, back to just the short name at paragraph 17. No learning additional rules in order to be able to use the guide. So just trying to lower that barrier to access. That's it, everybody. Questions? Comments? Rotten Tomatoes?
So feel free to put your questions in the chat if you had them, or unmute yourself, raise your hand. I'm seeing lots of positive feedback anyway.
Oh, we've got a question about citation management. We are working on that actively. We've recruited a very keen fellow. He's helping us out with that. I'm in the process of reaching out to Hein online because they do offer citations for some of the journals that they use. So we are working on getting Cole integrated with citation management. We're working hardest with Zotero, but and then oh, I'm forgetting the name of the other one right now.
Tourism.
Jurism. Thanks, James. But yes, absolutely.
And I'm seeing questions. Michelle, were you done on?
Yes, I'm done.
Yes,
Yeah,
yeah.
go ahead.
I'm seeing questions about whether courts have accepted the guide, or if any courts are using the guide. Part of my responsibility on the as a managing editor is to contact all of the courts in Canada and tell them about the guide, encourage them to use the guide. And so we've had some interest shown from some courts. We don't know that any courts are using it at the present time, but for example, James and Michelle and I will do a presentation to the Nova Scotia courts next month, to all three levels of courts, to the judges. My judges here at the Court of Appeal for Saskatchewan, I think they're going to be making a decision in the next month or two. I suspect that in Saskatchewan we will be moving to Cole. So the answer to everybody there is that it's a work in progress. So.
And we have had discussions with some of the courts who are waiting until the French version comes out. So later this year, we expect more movement on that based on previous discussions.
That's right. Very good point, Michelle. Yeah.
I see a question. Do you have any info on what people's experience has been using this in courts? Any friction there?
I'm not aware of any.
That's a great question.
Yeah.
No, most of again, I'm in an academic law library, so I can say the law review next to me is using it, and they're not having issues using it, but they submit, they do their own publishing thing. U of A, I think, has also changed over. James, I thought UBC was changing over as well. So the initial change seems to be with the law journals who are going with it. Students don't want to have to pay for the McGill guide, of course. I would suspect that self-represented litigants are going to end up using it, or have used it already, somewhat accidentally, because it was the thing that they were able to find available to them. And I haven't seen any issues based on that, but that is a bit of conjecture on my part. No, we haven't. I haven't seen any reaction from McGill. Have any of you?
I heard through the grapevine that they're not happy, unshockingly, but I have not received any direct reaction from McGill now.
No, I had a frosty conversation with our Thomson Thomson Reuters rep after we first presented this, but that's about as close as I got to feedback.
Yes, and I've heard nothing.
Are there any other questions? Oh, there's another question. Has there been any progress in getting the guide on the Canley homepage?
Yeah,
It's
so
a bit tricky to
Canley,
find.
oh, sorry. Yeah, Canley's saying they're going to add the guide to the homepage. They're also talking about revamping their homepage in general, so I think they're waiting to do that. So how long that's going to take, who knows? But they are planning apparently to add it to the homepage. Like I said, the comment says it's a bit tricky to find without the citation. Like I said, if you just type Coal Guide into the search box, it comes right up. Or if you just Google Coal Guide, it comes right up also. So yeah, trying to remember the citation is not the not the easiest, just kind of a random number. But yeah, if you just Google it or type it Cold Guide into the search box in Canley, it should come up for you.
Yeah, I can confirm most of my students are just Googling it. Oh, we've got a question about bibliographies, which I'm happy that we got. That is one of the things that I think we'll be addressing in the newer version. But for now, our guidance on that is we don't prescribe any difference. There's nothing in there to say that there's a difference. If you see a style issue that you notice you could go one way or the other on, what Cole does say is to reference another existing style guide like APA or Chicago.
Actually, we don't say that yet, but we're going to probably add that when we remind, we kind of, we were going to put it in and we kind of didn't, and we went back and forth on it, but I think we'll add it soon, yes.
Oh God, too many meetings. I just assumed it was in there. Yes, Thompson did know that. Yeah. I don't think they believed it was going to happen because it was a lot of work. So while it was in progress, I really don't think that they considered it was going to be an issue.
And thank you,
Thank you so
Frederick,
much,
for
Frederick.
your
Yeah,
comment. Yeah, that's great.
that really
that's
means a
great.
lot.
Yeah.
Question, any consideration of military materials? We have not added that yet, and I don't even think it's on our list, but I can absolutely make a note of that and we'll add it to our list of things to eventually add to the guide. Thank you for bringing that up.
If you want to email us to give us more information on that, I think that would be appreciated as well. That's a
Yeah.
really excellent one.
Yeah, the types of things that are of interest, both to you specifically and to people broadly speaking, would be amazing.
Any more questions? Have we run out? We've hit a lull. I think for some of you, it's probably pretty close to lunch. Oh, there's one. Do you think a print version will ever be made? Thinking on accessibility.
I know, for example, like Courthouse Libraries BC has like prints it themselves, and will give it to people. I don't know that we'll be making a print version ourselves because we don't charge anything for it and we don't therefore have any money to send it to print. I think it kind of goes a bit against our free aspect of things, but we are certainly fine with people printing it. We're not going to, raise any copyright concerns or anything like that. So if you want to print it, please go ahead and do so.
Yeah, I think that goes to the licensing that we have on the front, which is just if you want to print it, use it, do whatever you want. It's basically it's the Canley license, but it's a CC BY. So use whatever with the attribution. We don't care.
For the call conference, as you know, we don't have a budget, but we made our own swag. Or we didn't make the swag, but we paid for it, so we each contributed. So, I have another swag part. I'll be right back. Hang on. So we had that handy dandy bookmark, and then a card explaining about it. So we handed that out at call. So, but we funded that ourselves, as I said. So
We are working on possible sources of funding for a website at least to host all of this. So yeah, the zero funding aspect gets in the way of it sometimes. But just to, it's on Canley, but for some of this additional stuff, it would be nice, but that is a future project.
Oh, Rosalie, it could be a great Canley giveaway at the call conference, a print version. Yes, it would be.
Yeah, prior to today, I hadn't actually heard anybody ask for a print version or
Yeah.
a print version. So yeah, certainly.
No, I
seems
know a bunch
Interesting.
of other librarians have done what the Courthouse Libraries BC have done, which is also just printed off, but it would be nice to have a whole official thing. Yeah. Ah, thanks, Emily.
Okay, we have 10 minutes left. Are there more questions or comments?
And if anyone does want to change what they're teaching or quick slides on this, I'll put my email in the chat. I do have slides drawn up. Something else, a website would be useful for teaching materials. So if you don't want to work it all up yourself, I've done so many PowerPoints on this, my friends. just send me an email, I'll send it to you.
Okay. Perfect. Thank you, Michelle. Well, thank you to our speakers for sharing their work with us and for making it available for free to all of us. I think it's really important, and it's really important for access to justice. And I'd also just like to share that this webinar has been free for everyone, including non-members, just to kind of highlight and share some of the benefits of having a membership with the Canadian Association of Law Libraries, to those working in the legal profession, in case you were thinking about joining and you're maybe fence sitting. So a big thank you also to the CALL Board of Directors for approving the request to make this webinar available for free for all. Just knowing what an important topic it is. And with that, if there are no more questions, then I think we're done.
Thanks, everyone.
Very appreciate your coming. Appreciate your support of the guide.